Criminal justice system, legislation under the criminal justice system. Criminal justice system. A definition. The criminal justice system, CJS, is the structure of legal and institutional mechanisms established by the state to maintain law and order, prevent and control crime, deliver justice, and rehabilitate offenders. It includes all agencies, institutions, and processes involved from investigation to adjudication, punishment, and reintegration of offenders. The system aims to ensure fairness, public safety, and the rule of law, while protecting the rights of victims and accused persons. B. Components of the criminal justice system. The criminal justice system operates through several interconnected components. 1. Law enforcement. Role: first responders who detect and investigate crimes. Agencies: primarily the police, but also includes special units like the CBI, NCB, or cybercrime cells. Functions: registering FIRs, first information reports. Investigating offenses. Arresting suspects. Maintaining public order. 2. Prosecution. Role: legal professionals who represent the state in criminal trials. Agencies: public prosecutors appointed by the government. Functions: reviewing evidence collected by police. Framing charges. Conducting trials on behalf of the state. Ensuring justice, not just securing convictions. 3. Defense lawyers. Role: represent the accused and ensure a fair trial by protecting their legal rights. Functions: advising the accused on legal options. Challenging prosecution evidence. Presenting evidence and witnesses in defense. Ensuring due process and constitutional rights. 4. Courts. Role: adjudicate criminal cases and deliver justice. Structure: lower courts, magistrate and sessions courts handle trials. High courts and the Supreme Court deal with appeals and constitutional matters. Functions: conduct fair and impartial hearings. Interpret and apply the law. Pass judgments and issue sentences. 5. Corrections. Role: carry out sentences imposed by courts, primarily incarceration. Institutions: jails, prisons, reformatories, juvenile homes. Functions: confine and monitor convicted individuals. Offer rehabilitation through education, counseling, skill development. Protect society from offenders. 6. Probation. Role: an alternative to imprisonment, where the offender is allowed to live in the community under supervision. Functions: supervised freedom for first-time or minor offenders. Behavioral monitoring by probation officers. Focus on reform, not punishment. Used in both pretrial and post-conviction stages. 7. Parole. Role: conditional early release of a prisoner before the completion of the sentence. Functions: given for good behavior, emergencies, or humanitarian grounds. Subject to conditions like reporting to authorities, travel restrictions. Aims to facilitate reintegration into society. Legislation under the criminal justice system. Juvenile Justice, Care and Protection of Children, Act, 2000. 1. Definition. The JJ Act, 2000 was enacted to provide care, protection, treatment, and rehabilitation for children in need, and to deal with children alleged to be in conflict with the law. It emphasized rehabilitation over punishment and was aligned with the UN Convention on the Rights of the Child. 2. Child in Need of Care and Protection, CNCP. Includes children who are orphans or abandoned, victims of abuse, neglect, or exploitation, homeless, beggars, or street children, mentally or physically challenged, found working in hazardous occupations. 3. Children in conflict with the law, CCL. Refers to children below 18 years of age who are alleged or found to have committed an offense. The focus is on rehabilitation and reintegration, not punishment. B. Juvenile Justice, Care and Protection of Children, Act, 2015. This act replaced the 2000 law and introduced several key changes. Special provision for heinous crimes. Children aged 16 to 18 years may be tried as adults for heinous offenses, like rape, murder, subject to assessment by the Juvenile Justice Board. Strengthened the roles of child welfare committees, CWCs, and juvenile justice boards, JJBs. Emphasized adoption procedures and established child care institutions, CCIs. Improved mechanisms for the rehabilitation and social reintegration of both CNCP and CCL. C. The Immoral Traffic Prevention Act, 1986, ITPA. Originally known as the Suppression of Immoral Traffic in Women and Girls Act, 1956, this act was amended to become ITPA in 1986. Aimed at preventing human trafficking and commercial sexual exploitation. Key features. Penalizes trafficking, brothel keeping, pimping, and soliciting. Offers provisions for rescue, rehabilitation, and protection of victims. Focus on decriminalizing victims and targeting exploiters. D. The Probation of Offenders Act, 1958. Encourages the reformation of first-time or minor offenders by offering an alternative to imprisonment. Key provisions. Courts may release offenders on probation after due conditions. Involves supervision by probation officers. Focuses on rehabilitation within the community, avoiding stigma. Particularly relevant in juvenile and social defense contexts. E. Beggary Prevention Act, 1959. A state-level law, in different versions, enacted to prevent and control beggary. Main features. Defines beggary and criminalizes it. Provides for arrest, detention, and rehabilitation of beggars. Often criticized for criminalizing poverty rather than addressing root causes. Many states are now revising or repealing this act in favor of rights-based rehabilitation approaches. F. Narcotic Drugs and Psychotropic Substances, NDPS, Act, 1985. Enacted to regulate and control operations related to narcotic drugs and psychotropic substances. Key aspects. Punishes production, possession, sale, and consumption of illegal substances. Categorizes punishments based on quantity and type of drug. Recent reforms emphasize treatment and rehabilitation for addicts instead of only punitive action. Important in dealing with drug abuse among youth and marginalized groups. G. The Prisons Act, 1894. One of the oldest laws regulating the functioning of prisons in India. Provides rules for administration and discipline in prisons. Treatment of prisoners, including medical aid, classification, and labor. Appointment of prison staff. Criticized for being outdated, with calls for reforms to focus more on rehabilitation and prisoner rights. Supplemented by Model Prison Manual, 2016, for modern standards.
Thank you so much for watching. Don't forget to like, share, and subscribe. See you in next video.